Yes, good evening to everybody. That aspirants of the PG-LCET 2022 conducted with Osmania University, and we are dealing the labor laws. And today is the part two, the end part of it. With these 16 questions, marks are over. Tomorrow, I believe that it is a penal law. Penal code, if I not be mistaken. Now, without wasting the time, now you see that what I posted on the screen. Anyone can unmute and read what I posted on the screen, so that I could know that you could see the screen.
Industrial labor and general laws theory and MCQs.
Yes, what about this one?
Enlightening us with unbounded wisdom, this Guru Purnima lets value and follow the guidance and knowledge which we have received from the Gurus in our lives.
Yes, because after the parents, the role played by the guru, that the teacher is an important factor in the life. He molds the life. So we should not forget the sacrifices of the teacher, and we should regard them. Whenever you go to your native place, please try to meet the people, those who are alive now, either primary school or secondary school or intermediate or degree, whatever it may be. So that's what I want to say. So without wasting the time, now let us come to our study is PG-LCET 2022 University College of Law, Osmania University, Labor Law Multiple Choice Question, Part 2. That's the end part of it today. Okay, a few questions I would like to deal then, and I will hand over the host to our Kolikonda Sharad Babu. Yes, the first question goes in this manner. The basic principle underlying the enactment of the Trade Union Act is option A, to protect the interest of the workers against the disregard of human elements in the industry. B option, to regulate the relationship of the workers and their organization by regulating the balance of the power. C option, to provide the strength to workers to settle the industrial disputes. And D, the last option, is to provide the security to workers against the occupational hazards. Among the four, yes, what is the basic principle underlying the enactment of the Trade Union Act is?
Option is, sir.
No. The basic principle. Trade Union
Option B,
Act.
sir. Option B.
No.
Option C. Strength and to avoid the settlement.
No.
Option B is the correct answer, sir.
Yes. To
Please, sir,
regulate the
option C.
relationship of the workers and their organizations by regulating the balance of powers. That is the Trade Union Act, the basic element. Other three are not that much directly connected with it. So the first question, the right answer is B.
B.
Option. BAG bag B. Now let us go to the second question. Recognition of the trade union is made by the provision of dash. A. Trade Union Act of 1926. B. Industrial Dispute Act of 1947. C. Code of Discipline. D. Factories Act of 1948.
Trade Union Act 1926.
It is clearly given in the self-explanatory in the question itself. Recognition of the trade union by the A. Trade Union Act of the 1926, the right answer.
Yes, sir. For option A is our correct answer.
Option A, Apple A, is the right answer for the second question. Yes, anyone can unmute and read third question.
Which is not a structure of trade union of industrial organization? A. Craft union. B. General union. C. Industrial union. D. Consumer union. Sir, option C, sir, I guess. Option C is industrial
Which
union.
is not structure of the trade union, industrial organizations.
Not,
If you closely observe A, craft union, yes, it is a little touch with that one. General union, industrial union. But when you come to the matter of the D, consumer union, the Consumer Act is there, they're separate, which is entirely different. So the right option is
D.
D.
not, yes, that is a D. That is the consumer union is not related to the trade union industrial organization. The third question right answer is D, DOG dog D. Okay, now the fourth question. The following persons are considered as the insider of the registered trade union. Option A, honorary member from the other organization. B, option honorary member from other profession. C option, politicians who guides the registered trade union. D option, retired and retrenched member of the trade union. Insider of the registered trade union, I am speaking. Among the four,
Option C is a politician.
No, that is not correct.
Kolikunda Sharad Babu, tell me the right answer.
D is the right answer, sir. It is retired and retrenched members of the trade union. That is the
They are the insider of the
insider
registered trade union.
trade union.
Okay, the fifth question. Dash provides the financial assistance to compensate the loss of his or her wages during the period of his abstention from work due to sickness, maternity, and employment injury. Option A, Trade Union Act 1926. B, Employee State Insurance Act 1948. C, Industrial Dispute Act 1947. D, Apprentice Act 1961.
Sir, option B, sir. Plus state insurance.
Yes, option B is the correct answer, sir.
Yes,
Employee State Insurance Act 1948.
it's a
Insurance we can
ESI.
cover all this, sir.
It's a ESI is a federal government, central government, is it not?
Yes, sir.
Then the sixth question. When did the Employee State Insurance Act 1948 come into force? A, 1st April 1966. B, 1st March 1967. C, 1st May 1960. D, 19th April 1948.
Sir, 19th April 2014, option D.
You are right.
Yes,
It is the
it is
19th April 1948 is the right answer for the sixth question. That is the D is the right answer. Seventh question. Which section of the Employee State Insurance Act 1948 deals with the expenditure by the central government to be treated as a loan? A, option, Section 37 of the Employee State Insurance Act of 1948. B, Section 34 of the Employee State Insurance Act of 1948. C, Section 31 of the Employee State Insurance Act of 1948. D, Section 39 of the Employee State Insurance Act of 1948. Among the four, which one is the appropriate answer for that one?
Sir, section 31 of the Employee State Insurance Act 1948.
You are right.
Oh,
The 31 of the Employee State Insurance Act of 1948 is the right answer for the seventh question. That is the C. Okay, next. Anyone can unmute and read the eighth question.
Employee State Insurance Act 1948 is applicable to non-seasonal factories employing dash persons. A, 10 or more. B, 20 or more. C, 5 or more. D, 25 or more.
Sir,
it's
B,
10
sir.
or more, sir. A answer.
A is the right answer. That is the
A
10
is the
or more. Is the eighth question. Right answer is 10th or more. The A is the right answer. The ninth question is the ESI scheme is yet to be implemented in dash A, Arunachal Pradesh. B, Lakshadweep. C, Jammu and Kashmir. D, both A and B.
Sir, C, sir, Jammu and Kashmir.
No,
I think D, sir, A and B.
The right answer
B is
is
the correct answer.
D is the right
B.
answer.
Lakshadweep. It is implemented there.
Okay, next 10th question. What is the present wage limit to be eligible under the Employees Provident Fund and Miscellaneous Provision Act of 1952? A, rupees 8,000. B option, rupees 12,000. And C option is 15,000. And the D option is no wage limit.
It's B, 12,000.
No,
Second option.
8,000, sir.
no.
I think no wages.
The correct option is D. There is no wage limit. There is no wage limit.
Yes, now I switch on to the Kolikunda Sharad Babu. You can continue from the 11th question.
Yes, sir. Good evening, one and all. The
Good
payment of bonus act 1965 is applicable to an employee who draws wage or salary of A, 3,500 rupees in case of apprentice. B, rupees 5,000 in case of apprentice and employee. C, 7,500 rupees in case of employee only. D. Rupees 10,000 in case of employee only.
Sir, B, sir, B. B, sir. B is the answer.
Option D is the correct answer.
D, huh?
10,000.
Rupees 10,000 in case of employee. So that is Bonus Act 1965 is applicable. Now the 12th question is, payment of Bonus Act 1965 is applicable to every factory and to every other establishment where dash workmen are employed on any day during an accounting year. A. 20 or more, B. 10 or more, C. 50 or more, D. 30 or more.
10 or more.
Is wrong answer?
20, sir.
Yes,
A.
option A is the correct answer, 20 or more. Now, 13th question is, the minimum bonus which an employer is required to pay even if he suffers losses during the accounting year or there is no allocable surplus is dash % of the salary or wages during the accounting year. A. 10%, B. 20%, C. 8.33%, D. 6.33%.
C, sir. 8.33.
Yes, that is the correct answer. 8.33% is the correct answer. Now, 14th question is, which section of the Payment of Gratuity Act 1972 deals with the mode of payment of gratuity? A. Section 12 of the Payment of Gratuity Act 1972. B. Section 9 of the Payment of Gratuity Act 1972. C. Section 14 of the Payment of Gratuity Act 1972. D. Section 20 of the Payment of Gratuity Act 1972.
Section 9, sir.
Yes, that is correct answer. Section 9 of the Payment of Gratuity Act 1972 deals with the mode of payment of gratuity. Now, 15th question. According to Dash, Payment of Gratuity Act 1972, completed year of service means continuous service of 1 year. Continuous service for 1 year. A. Section 2A, B. Section 3A, C. Section 2B, C. Section 3D.
Sir, C, sir. Section 2, subsection B.
Yes, option C is the correct answer. Section 2B.
Yes, sir.
According to that, the completed year of service means continuous service for 1 year. 16th question. What is the maximum gratuity payable under the Act at present? A. 20 lakhs, B. 15 lakhs, C. 45 lakhs, D. 60 lakhs. At present, it is applicable, the maximum gratuity.
20 lakhs. Sir.
Yes, 20 lakhs is the correct answer. A. Option A is the correct answer. Now, question number 17. Sir, please scroll down. Section 4A of the Employees Compensation Act 1923 deals with dash. A. Notice and claim. B. Commutation of half-monthly payments. B. Compensation to be paid when due and penalty for default. D. Contracting out any contract or agreement.
Sir,
Section
option B,
4A.
sir. Communication
No.
portal.
Option C is the correct answer. Compensation to be paid when due and penalty for default. Now, question number 18. Dash of the Employees Compensation Act 1923 provides returns as to compensation. A. Section 15. B. Section 10. C. Section 8. D. Section 16.
Section 10, sir.
No, wrong answer. Section D is the option D is the correct answer. Section 16. According to that section, Employees Compensation Act 1923 provides returns as to compensation. Now, question number 19. Which is the correct order of settlement of industrial disputes? A. Industrial Tribunal. B. National Tribunal. C. Conciliation. D. Labor Court. Now, choose the correct order of adjudication. A. Capital A. CADB. B. CDAB, C. ADCB, D. CBDA.
Sir, B, sir.
B.
B, sir.
Yes, option B is the correct answer. First it goes to conciliation, then it goes to labor court, then it goes to industrial tribunal, finally national tribunal. So B is the correct answer, CDAB. Now 20th question is, first come, last go, and last come, first go is the principle of A. Layoff, B. Closure, C. Retrenchment, D. Dismissal.
A, sir. A.
No,
Retrenchment, sir.
yes, option C is the correct answer. Retrenchment. First come, last go, and last come, first go.
సార్
21st question.
రిట్రెచ్మెంట్ అంటే ఏంటి సార్?
Removing from the staff, that is
If the
removing
excess
from work.
staff is there and they don't need it, and at the time, the last come is first go would be there. That is retrenchment.
In retrenchment, whenever the demand is there, again they may be called. So
Yeah.
that is the difference between retrenchment and dismissal.
Yes.
For time being, they'll remove, sir. Again, if they require, they
Yes.
will again hire them.
Yes, that is
సార్
retrenchment.
లే ఆఫ్ మీన్స్ ఎంటైర్ ఆర్గనైజేషన్
That
లే
is by the management. Closure and layoff both are by the management.
ఎంటైర్ ఆర్గనైజేషన్.
Yes. Now, 21st question is, the right to strike is A, fundamental right, B, a legal right, C, no right at all, D, none of the above. This question has
Yes,
come
sir.
in Tamil
లీగల్
Nadu
రైట్ సార్.
employees
లీగల్ రైట్. బి
strike.
A, sir.
No,
బి లీగల్
Legal
రైట్
right
సార్.
to-
బి
then B,
yes,
legal
it is only a legal right, it's not a fundamental right. The Supreme Court has given that judgment in the case of Tamil Nadu employees strike when Jayalalitha ruled the state. 22nd question. Which of the following is not an industrial action in India? A. Strike, B. Lockout, C. Picketing, D. Mass casual leave.
For mass casualty,
Yes, that is the correct answer. D. Mass casual leave is not an industrial action in India. The others are industrial actions: strike, lockout, picketing, etc. Now, 23rd question. As per Industrial Relations Code, no employer or worker from an industrial establishment can go on strike without giving. No employee or worker can go on strike without giving A, a 30-day advance notice of the strike to the employer, a 14-day advance notice of the strike to the employer, C, a 15-day advance notice of the strike to the employer, D, 40 days advance notice of the strike to the employer.
B, 14 days advance notice.
Yes, that is the correct answer. A 14-day advance notice of the strike to the employer should be served. No employee can strike without reporting a strike to the employee 14 days in advance. This notification is valid for a maximum of 60 days. Okay, now 24th question. As per Industrial Relations Code, no employee or workers from an industrial establishment can go on strike without giving a dash notice of the strike to the employer.
30
A,
days.
30 days, B, 35 days, C, 55 days, D, 60 days.
A, sir.
I have given in the feedback itself
60
the
60
answer.
days, sir. 60 days. 60 days.
60 days.
It is there in
Option
the
D is the
feedback
correct
itself.
answer.
Yes, sir.
60 days. Now, question number 25. The Industrial Disputes Act 1947 requires advance notice to be given for going on strike and lockout in public utility service only. Which of the following specific service serving of notices for strike and lockout in non-public utility services also? A. Interunion Code of Conduct, B. Codes of Discipline in Industry, C. Code of Efficiency and Welfare, D. None of the above.
Option B, sir. Code of discipline in India.
Yes, option B is the correct answer. Code of discipline in industry. Now, question number 26. Strike is not expressly recognized in the Constitution of India. The Supreme Court settled the case of Dash on 7th of July 1958 by stating that strike is not a fundamental right. Government employees have no legal or moral rights to go on strikes. A. All India Bank Employees Association versus National Industrial Tribunal. B. Balakotaya versus Union of India. C. Commissioner Prasad versus the state of Bihar. D. None of the above.
Sir, option C, sir.
It is the Kameshwar Prasad versus state of Bihar. It is decided that case. The right answer is C.
C.
Okay,
C.
let me deal from the 27th. Yes, 27th question. India recognized strike as dash under the Industrial Dispute Act, which came into force on April 1st, 1947. A. Fundamental right. B. Legal right. C. Moral right. D. Statutory right. I say under the
Legal right.
Industrial Dispute Act.
Your voice is breaking. Your voice is breaking, sir.
It is not a
It's
fundamental right. There is a
legal
obvious
right.
factor. Of course, just before that we said that it is a legal right. Okay. But in this case, under the Industrial Dispute Act, it is a statutory right.
Yes.
28th question. Which one is odd man out regarding the strikes, which is not connected with the strike? Option A strike is a powerful weapon used by trade unions or other associations or workers to put across the demand or grievances by the employers or management of industry. B option. In other way, it is a stoppage of work caused by the mass refusal in response to grievances. C option. Workers put pressure on the employer by refusal to work till fulfillment of their demands. The D option. Strikes may be fruitful for workers' welfare and it may not cause economic loss to the country.
Option C, sir.
Read.
Workers put pressure on the employees by refusal to work till fulfillment of their demand.
There's a very much connected to the strikes.
Yes, sir.
Option D is the answer, I think.
Option D, I said strikes may fruitful for workers. It's very good. Welfare, it may not cause economic loss to the community. No, it may cause economic loss to the community, to the country.
It will definitely cause.
It may cause economic loss to the country. So it is against to the strike is the odd man out. The answer for that is D. Is it clear?
Yes, sir.
Yes, sir.
The negative way of asking this thing is 29th question. Which is or was the world's largest ever strike? A. In March 2012, nurses employed by the different hospitals in Chennai went on strike. B option. In January 2014, Kingfisher employees went on a hunger strike due to the non-payment of salaries. C. In September 2016, Indian workers of public sector had gone strike demanding the higher wages. D. None of the above. The world's largest ever strike.
Option A, sir.
No.
Option C, sir.
It is option C. In September 2016, here the feedback I have given. In September 2016, tens of millions of Indian workers of public sector had gone on strike demanding the higher wages. Banks, power stations were kept shut and a public transportation system froze in some of the states. Later, the government considered their demands and increased the wages. It was world's largest ever strike. Please note the point.
And in
Labor
this
law. Yes.
in this case, there is logic also, sir.
Yes.
Nurses do not amount to large number,
Okay.
and so the Kingfisher employees also may not be so large, but whereas the Indian public sector is considered,
So many
when the
people
number
are
of
there.
employees, so many workers are there and employees are there. That's why it can be considered.
Yeah, it is the largest one in the world. The world largest
Where
labor
it started,
strike.
sir? Where it started, sir? In which state or where?
All the states,
All
all
over
the
world war.
states.
All
No,
banks, power stations, they all are
Indian
demanding the higher wages. Please note the point. In the labor laws, there is no salary, there is no honorarium, there is no other thing except the wages, the word that you use it. 30th question.
Yes, sir.
Under the following situation and on these grounds, the strike can be considered as illegal. I say illegal. Find the odd man out, which is not connected with the illegality. Option A, without giving to employer a notice of strike within 6 weeks before the striking. Or B, option within the 14 days of giving such notice. C option, before the expiry of the date of strike specified in any such notice as aforesaid. D, during the pendency of any conciliation proceedings before a conciliation officers and 6 days after the conclusion of such proceedings, which is not connected with the illegal strike.
Option D.
Option D is the right answer. During the pendency of any conciliation proceedings before a conciliation officer and 6 days after the conclusion of such a proceedings. The answer is during the pendency of any conciliation proceedings before a conciliation officer and 7 days after the conclusion of such a proceedings. If 7 days would be there, then we can say it is illegal. It is a strike can be considered as illegal. But if it is a 6 days would be there, it is not considered to be the illegal. Is it clear?
yes, sir.
31st question. In the case of Dash, the court held that a strike can be considered justified if it is in connection with a current labor dispute or directed against an unfair labor practice of the employer. Option A, in the case of Technological Institute of Textile versus its workmen and others. Option B, Cox and Kings Limited versus their employees. C, Management of Bangalore Woolen, Cotton and Silk Mills Company Limited versus the workmen and another. D, Workmen of the Swadeshi Cotton Mills Company Limited versus Swadeshi Cotton Mills Company Limited, Kanpur and others. In which case law, it is made it that a strike can be considered justified if it is in connection with the current labor dispute or directed against an unfair labor practice of the employer. At the time, there is a justification to strike, in which case law it is decided.
Option D, sir.
It is the option B, Cox and Kings Limited versus their employees. In that case law it is decided. It is justified.
If there is unfair labor practice
Yes, there is
by the
unfair labor
employer,
practice was there.
then the strike is legal.
Yes. 32nd question. Based on the phenomena of strikes around the world, strikes can be categorized into dash. Find the odd man out. It means which one could not be type of a strike. A, economic strike. B, sympathy strike. C, general strike. D, special strike. Shoot, even though it is wrong, doesn't matter.
B, sir, B.
Read.
I think A is the answer, sir, because there is no economic strike.
No, there is there in the world level. There is economic strike, there is a sympathy strike, there is a general strike, but there is no special strike.
Okay, so the answer is D.
Answer is D. The 33rd question, 33 question, which is not the kind of strike. Again, A, sit down strike, B, pen down strike, C, slow down strike, D, hunger strike.
Hunger strike.
No, it is a form of a strike, hunger strike is.
Yeah, hunger strike is there.
I think A is the answer. Sit down strike.
No,
Pen down strike.
It is a pen down strike. The
What
pen
is the
down
meaning of
strike will be done by the officials. I mean, white collar jobs holders. It's not the workers, not the laborers. Laborers are come under the blue collar job. Is it clear?
like advocates come under white collar?
Yeah, it's the white collar. It's not a blue collar.
Yes, sir.
So
Shall I
workers
proceed?
generally don't use pens. That's why there is no strike, pen down strike for labor.
Okay.
Shall I proceed? 34th
Yes, sir.
question.
Okay, sir. Okay, sir.
There is also be a strike which will be known as dash have been experienced. A. Wild boar strike. B. Wild canine strike. C. Wild kitten strike. D. Wild cat strike.
Wild kitten strike. The option.
There is a wild cat strike is there, but there is no wild boar strike is there. If you search Google it, the wild cat strike, what it says. If any person is stubborn over there, at the time they will make it a necessity to make it out, to make him pressure that I believe that the wild cat strike, they will give the explanation. Actually, I should have to give in the feedback what is the wild cat strike. Okay, now later, when the time left over there, then I will read. Yes, Korikada Sharad Babu, continue with the 35th question.
Yes, sir. In 2004, advocates went on wildcat strike at civil courts in dash to protest the remarks allegedly made by an assistant commissioner against them. A. Pondicherry. B. Bangalore. C. Tamil Nadu, that is Madras. D. Kolkata.
Option C, sir. Tamil Nadu.
No. Second
No.
option?
D, sir.
Bangalore.
Option D, sir.
No, it is option B, Bangalore. They made the wildcat strike, the civil courts, to protest the remarks allegedly made by an assistant commissioner against them. A professional can make it a wild
So it
cat strike.
was the remark made against the advocates.
Yes, because
36
advocate is also a legal officer.
Yes.
And 36th question, read.
If we see the history of strikes, it is found that strikes mostly occur due to issues related to dash by the employers to the workers. A. Holidays. B. Working conditions. C. Wages. D. Types of leaves.
Sir, option C, wages.
C, wages, sir.
No.
Yes, because anything generally strikes, the main motto is wages, not for the holidays,
Is it,
not for the working
is it
conditions.
not? Is it not
Mostly,
working conditions? Sir?
no.
Okay.
Mostly, I say that's why if you see the history of strikes, it is found that strikes mostly occur due to the issue related to wages.
Wages.
Is it clear?
Yes, sir.
Now, 37th question is, in the case of dash, Central Government Industrial Tribunal, it was held if a person was employed in public utility services, then he or she cannot go for a strike without the consent and gathering the procedures which must be satisfied in the provisions. A. Workmen of the Motor Industries Company Limited versus Management of Motor Industries Company Limited. B. Ballarpur Collieries Company versus the presiding officer. C. ILO Chief Gammon versus Industrial Tribunal, Bhubaneswar. D. Commissioner of Income Tax versus Messrs. Monica Oswald Jawaharlal.
Sir, option C, sir. Option C.
It is a Bollarpur Collieries Company versus the presiding officer. It was decided that one cannot go without the consent of the gathering, because the collieries is a mine. In the mine, when you make it out, of course it can be given over there, but there is still procedures are there. With the procedure only that you have to go on, otherwise the whole production will be stopped. And a heavy loss, because in the mine every 3 months bonus will be given, because It's a good industry, profitable industry, and more risky industry also. If it comes to the matter of underground mine, but now all the mines are open cast, hence the probability of the casualty is less. Okay, next 38 question.
Section 24 of the Industrial Dispute Act 1947 provides that strikes which are in non-compliance to section dash and section dash are illegal. A. 21 and 22, B. 22 and 23, C. 23 and 24, D. 24 and 25.
Sir, B, section 22 and 23.
Yes, it is a section 22 and 23, they have to comply it before they are going to make the strike of 24. Unless until you comply the 22 and 23, the procedures, one cannot go for the strike. Yes. 39th question.
In dash Supreme Court, it was observed that if a strike is legal as well as justified, then the worker is entitled to wages for the period of strike. The strike should be legal and justified. A. Crompton and Greaves Limited versus Workman. B. Philips Private Limited versus General Motor Company. C. Bajaj Electronics Gadgets versus Union of India. D. Ellora Digital World versus State of Telangana.
So the option B, Philips Private Limited versus General Motor.
No. Second option.
Bajaj Electronics Gadget versus.
No. See, the Supreme Court in this case law observed if the strike is illegal as well as justified, that the workers is entitled for all the period of the strike, and it should be legal and justified. It is decided in the Crompton Greaves Limited versus Workman. And you know what is Crompton Greaves Limited? What they manufacture?
They manufacture fans,
Fans.
Tube lights.
some other gadgets also.
Yes.
Yeah.
So it is the Crompton Greaves versus Workman. It is decided if the strike is a legal one, all the period of the strike, the wages will be paid. Next 40th question. The Factories Act. Read.
The Factories Act of which year? A. 1946, B. 1947, C. 1948, D. 1949.
1946.
No. Second option.
1949, sir. D.
It is C, 1948. The C is the right answer for the 40th question. The Factories Act is of 1948. Next.
The Factory Act 1948 and the Act number of 1948. So you have to say the Act number. A. 60, B. 61, C. 62, D. 63.
61.
Wrong.
62, sir.
Option D.
Option D, 63 is the right answer for the 41st question. Okay, this I will read it. 42nd question. Match the following schedule in part A and the discipline in part B. Part A is the schedule, part B is the description. Number 1, the first schedule. Number 2, the second schedule. Number 3, the third schedule of the Factories Act. And its explanation is list of the notifiable diseases. B. Permissible levels of the certain chemical substances in the work environment. C. List of industries involved in the hazardous process. Now A. 1A, 2B, 3C. B. 1B, 2C, 3A. C. 1C, 2B, 3A. D. 1A, 2C, 3B.
Please scroll up, sir.
Yeah, because feedback is down. Which one is the appropriate answer? A or B or C or D? I'm speaking about the Factories Act. It is having the 3 schedules.
I think option C is the correct answer.
Option C is the correct answer. Read.
The first schedule, a list of industries involving hazardous process. In the second schedule, permissible levels of certain chemical substances in work environment. In the third schedule, list of notifiable diseases are there. So
So it
option
is,
C is the correct answer. 1C, 2B, 3A.
yes, it is. I coined it because I want to show to my students this technique also. Okay, read next 43.
43rd question. What is defined in section 2
M.
M of the Factories Act 1948? A. Director. B. Commissioner. C. Factory. D. Industry. Yes, section 2M. What
Section
is
2,
defined?
clause M.
Is it director or is it commissioner or is it factory or is it industry? What is defined by that section?
Is a self-explanatory.
Industry, sir.
It is a factory.
To know the factory.
So 2M defines factory.
Next.
44th question. Which of the following diseases is not mentioned in the section dash of Factories Act? Anthrax, asbestosis, phosphorus, pneumonia.
In the diseases,
Option
there are
four,
a
Option
list
four.
of the diseases are there. What
Option
are
four,
those
sir. Four.
diseases?
Option
Pneumonia,
4,
sir.
sir. Option 4, sir.
Option 4, pneumonia is not there. Because pneumonia caused with what?
That is
Hey,
caused
cold-
by
cold-
bacteria.
Cold weather, sir. Cold weather.
Number 1, cold weather. If it is too much fever is there, and
Yes.
your fever fluctuates over there, and it's not controlled, it goes to the pneumonia.
Yes, sir.
So next option you did not say. Section dash of Factories Act. Next
What, sir?
blank is there.
Yes, yes. That is B 87. Which of the following diseases is not mentioned in the section dash of the Factories Act? Anthrax, asbestosis, phosphorus, pneumonia. Oh, you are asking the section. That's A 186, B 287, C 388, D 489.
When you know the pneumonia, automatically the section also you can make it out.
89, sir. 89.
It is 89. Perhaps if you know the pneumonia is the right answer. Is it clear?
Yes, sir.
If you know the right
Now,
answer, pneumonia, then only you can make it out. Otherwise, you cannot make it out. Next.
45th question. Restriction on disclosure of information under section dash of the Factory Act 1948. A 117, B 118, C 118A, D 118B.
Restrictions and a disclosure of information.
So there should not be any leak of information
Yes.
to the outside.
Sir, 118A, sir.
C, 118 capital A
Yes, sir.
is the right answer. Okay, next.
46th question. Match the following in the Factory Act 1948. Part A deals with chapter and Part B is description. 1. Chapter 7, 2. Chapter 8, 3. Chapter 9, 4. Chapter 10. And description is A under Part B. Annually with wages, B. Employment of young persons, C. Penalties and procedure, D. Special provisions. A. 1A, 2B, 3C, 4D. B. 1B, 2D, 3A, 4C. C. 1B, 2A, 3D, 4C. D. 1A, 2B, 3D, 4C. Sir, the first one, A should be 4 instead of 6, the last one in the A answer.
No.
No, sir, you have typed it as 6, that is 4.
Where?
In
Okay,
the first
okay,
A
okay,
answer.
okay. The options.
No,
Yeah, here. Huh?
in the first option.
Options,
Okay.
right. See here the feedback.
Chapter 7, Employment of Young Persons. Chapter 8, Annual Leave with Wages. Chapter 9, Special Provisions. Chapter 10, Penalties and Procedure.
So the right answer is
Option
1B,
A.
2A, 3D, 4C.
Okay, option B is the correct answer, sir.
Option C is the correct answer.
Yes. 1B, 2A,
3D,
3D,
4C.
4C. Yes.
Yes, I will read this one. 47th, match the following chapter from part A and description is given in the part B. Part A, chapter 2, chapter 3, chapter 4, chapter 5. Part B, the inspecting staff, health, C, safety, D, welfare. And here option is made 1A, 2B, 3C, 4D, but I did not get the chance to make the other things. So the feedback is chapter 2 is welfare, chapter 3 is safety, chapter 4 is health, chapter 5th is the inspecting staff. So this type of the question may also be asked you.
DCBA is the answer.
Yes, that is the right answer. So chapter 6A, provisions relating to the hazardous process. It is a chapter 4A. So they may ask also, provision relating to the hazardous process is given in the which chapter? Chapter 4, chapter 3, chapter 4 capital A, chapter 4 capital B. In this way also they may ask the question. So
Chapter
they
4
may
is
ask the
answer.
question in the schedules also, comparison, match the following. So this is the technique that which I would like to share with you. So at any time it will be stopped because time is going to up, and the next class we do have it. Yes, when you see the syllabus, yes, syllabus, yes, here. Yes, what is the syllabus? Next class. Yes, I can magnify it because yes, still 5 minutes are left over there for our. I want to magnify, but it is yes. This way also we can magnify it. We can enlarge it.
That
So
is
labor
crimes.
law, we did it the 2 days, and tomorrow is crimes and torts. Again, the 2 days, both mixing together, crimes and torts mixed together, and we'll deal the 2 days tomorrow in the same timings, India time 9:40 to 10:30, and the 2 days we will deal it. Then other laws are concerned, depending on the how much the availability of the time, either we can take the 2 laws in 1 day, so that I think total we do have the 8 laws. Is it clear? Other laws like the Copyright Act 1, Patent Act 2, the Environment Protection Act 3, Protection of Human Rights Act 4, the Salient Feature of the Information Technology 5, the Right of Information Act 6, and the Arbitration and Conciliation. I think it is the 8. Is it 7 or 8? 1, 2, 3, 4, 5,
6, 7, sir.
7 only. So we will see that in 7 days, 7 means we can complete in 3 days. So if we happen to make it crimes and torts tomorrow and after tomorrow, that means 14 and 15, then 7, 16, 17, 18, 19, oh, we can have the ample time. We can deal it in a extensive manner. Because say 7, at least 4 days we can make it out, or 5 days also we can take it. If the exam is 22nd, let me wind out on 21st, 20th, because 21st you can relax it, or you can travel. Suppose the center is different place. So by 20th, 20 we will wind it out. If it is not possible, definitely on 21st. But 21st may not be that much feasible. 28th is we would like to wind up our PG-LCET 2022. Yes, any questions? If you want to ask, you can ask me. To me or Kolikonda Sharad Babu. And I am very much
Okay, sir.
thankful,
Welcome.
Sharad Babu sir, even though he is there in New York From there, he is stealing it with his own mobile, not with the laptop. Even mobile, he is coining it and sending it to me.
No, sir. Now I have laptop, sir.
Very good, very good. When you have the laptop, why don't you make it like my style? See, whenever I make it now, I use the arrestor, not the full stop. I don't make the starter here. The beginning parenthesis is called starter, the ending one is called arrestor. That is the round bracket, or we can say curve bracket. But Professor Hussain students say parenthesis if it is two, the left hand side and right hand side. It is because how many types of the brackets are there? Anyone?
So that we can have a get together, some small felicitation and lunch or dinner.
But our first priority is that you must achieve the goal of cracking.
Yes, that is our motto.
Lost.
When you come to India, then we can make it out like that. Because I may come because of the holidays. I may fly to India. I may fly because 1 month. What should I do here?
Yeah, we'll be pleased to receive and
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
Jai Hind.